Can feel my body hold against the concrete, but I can't seem to get enough. My mind is fixed on what it wants. I just let you beat me, looks can be deceiving. Let you get the best of me, in bed with my worst enemy. This is a no-go, I just can't take hold. This is a danger zone, back up and get me home. This is a no-go, I just can't take hold. This is a danger zone, back up and get me home. So put your hand in mine, follow me, let me waste your time. Set up feet, do some stupid shit. Take a seat, let me waste your time. Slow beats up a time.
Hello, everybody. Welcome to the Lawyer's Den on the Pod TV network. I'm Nick Pellavita. I'll be your host for today's program. And we do want to welcome our people who are in the United States and the lawyers from around the world who are watching the Lawyer's Den, where the real lawyers debate the real issues. And today's issue we're going to have will be a very important one, which deals with the birthright citizenship. And you may have heard about this because Donald Trump has put an executive order down that birthright citizenship no longer exists. But the attorneys may have a different problem with this, and we're going to look at it today. So with that, we're going to introduce the lawyers on the Lawyer's Den. First, hailing from New York City is a gentleman who's received his law degree from the University of Miami and his master's in business administration from NYU. We're going to welcome to the Lawyer's Den for his first time at the Lawyer's Den, Peter Bennett. Peter, welcome to the Lawyer's Den.
Hi, Nick. Hi, everybody.
Yeah, we're going to have a great debate here on this birthright citizenship. And now we're going to head south. We're going to find a gentleman who also has a law degree from the Ohio State University and an LLM from NYU. And he's also went to USC, and he's a professor at Georgia College. So we're going to bring our professor in, Adam Lamparero. Welcome to the Lawyer's Den, Adam.
Thanks.
Of course, you've been a mainstay here, so a lot of people know about you and your kind words that you spread among the other attorneys. But now we also have a constitutional lawyer, a person who has an LLM in that particular area from George Washington. He was a former assistant attorney general from the state of Utah, and now he's a partner at Spencer Wilson. We're going to bring in our constitutional lawyer, Jeff Tigert. Jeff, welcome back to the Lawyer's Den.
Thank you.
Okay, we'll start with the opening statements. We're going to look at the area called birthright citizenship. And of course, we all know the issues that took place in the birthright citizenship, that Trump put an executive order down that birthright citizenship, no mas anymore. But there's also a little bit of a problem with it. We have a 14th Amendment, which does appear to allow people who are born in the United States to be citizens of the United States. So the real question is, does Donald Trump's executive order have any standing at all? And we're going to take a look at some of the case law. Some of the case law exists all the way back to 1898, U.S. versus Wong Kim Ark, which is the person from China who was born here, and the Supreme Court declared in 1898 that the person was a U.S. citizen. However, we also have another case that's in 1884, Elk versus Wilkins, where Native Americans that were born here were declared not to be U.S. citizens, which is kind of odd. And they had to pass a law in 1924 to allow them to be U.S. citizens. So with that, we're going to start with the opening statements from Peter Bennett. We'll get to you first, and let us get your opinion on the birthright citizenship.
Okay, so I like to begin shows where there are issues with a little background, and then I sort of save my strongest arguments for later. But if we look at the background, there are an estimated 10.5 million to 16.8 million illegal immigrants in the country. Some people believe more, very few people believe less. The Center for Immigration Studies estimated that illegal immigrants had between 2,250,000 births to 2.5 million U.S. births in 2023. That was 7% of all U.S. births. The same center also estimated that in 2020, there were 33,000 births to women with tourist visas. Basically, it's called birthright tourism, where people pay to come into the country or come into the country. But the thing is about both of these, and there are statistics on these, but not on the other ones, but I'm sure it's the same. I've heard of stories. A lot of these births are funded by taxpayer assistance, and also hospitals waive the costs on a lot of these births. So this is why it's a big issue in a country that is drowning in debt, I would add. So the other thing I would bring out initially about the background is that there were 3 constitutional amendments passed at the end of the Civil War, and they were designed clearly to protect the former slaves. The 14th Amendment, which is the one that we're debating now, was passed in 1866 and ratified in 1868. It basically was designed clearly to make children of former slaves U.S. citizens, but it also said all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that's where some of the debate comes in, is what do they mean by subject to the jurisdiction? The 13th Amendment was passed in December 1865, and it gave slaves the right to the same rights as the Bill of Rights. It extended those rights. The 15th Amendment, so we're talking about the 13th and 15th now, was ratified in February 1870. So all of these amendments came at about the same time, right after the end of slavery. And the 15th Amendment prohibited states from denying the right to vote, basically slaves and people in the United States who are legal. So basically, that's my opening statement in terms of the background, and then I'll, as I said, I'll save some of my stronger arguments for later.
Okay, we're going to bring in Jeff Teichert for his opening statements on birthright citizens. Jeff.
Thanks, Nick. Now, you know, probably if you've heard me on this program before, I tend to be more conservative, and I tend to, in general, be a supporter of President Donald Trump. But the problem this time is the plain language of the Constitution. Amendment 14, Section 1 says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, I've heard these arguments from people promoting that we can end birthright citizenship to suggest, well, there's some wiggle room in that subject to the jurisdiction thereof. I'm going to debunk that really quickly. First of all, the subject to the jurisdiction thereof. Now, look at the case of Pennoyer versus Neff, which has never really been overruled, although it's been expanded. The Supreme Court has said that presence is the touchstone of jurisdiction. If you're present in a particular state, the courts of that state have jurisdiction over you. You can be sued there. It's the same thing in the United States. If you're present in the United States, you can be sued there. You can be arrested. Now, people say, well, why is that even in there if everyone born here is simply subject to the jurisdiction of the United States? Diplomats have diplomatic immunity. They are not subject to the jurisdiction of the United States. But I've heard other people say, well, what about invading armies? Well, what about that? Are we really going to say that that United States Marshals, that our own soldiers or whatever can't arrest invading armies, can't shoot them, that they're not subject to the jurisdiction of our country? No, if they're here in the United States, unless they have diplomatic immunity and aren't subject to our laws because of that, we have jurisdiction over them. That's a very, very narrow exception. Can we, in terms of invading armies, I also want to say, how many pregnant women do you know that are here as part of an invading army? I think that's kind of a ridiculous issue. One final thought. I've heard a lot of people debating this from the standpoint of slavery, that slavery, that this really was to bring slaves and their children into citizenship. Fine, I'm with that. but the amendment itself says 0 about slavery. And so it was left much more general for a reason. And just in terms of the text of the amendment, I don't think you get beyond it with these kind of frivolous arguments that unless you have a U.S. passport, you're not subject to our jurisdiction or something like that.
Okay, last part of the opening statement, we're going to bring in Adam Lambrero, our professor, to see what he has to say about birthright citizenship. The floor is yours, Adam.
Thanks, Nick. So what I would say to the audience is imagine a woman going from Tijuana, crossing the border, going to San Diego, giving birth that evening, and returning to Tijuana. The text, some would say, suggests that that infant is automatically a U.S. citizen. But the text of the 14th Amendment is not as clear. It says that all persons born or naturalized in the United States and subject to the jurisdiction thereof. The key issue here is, what does subject to the jurisdiction hereof mean? And you have to look at the original meaning as understood by those who drafted it. And it didn't just mean being born physically in the United States. It also meant having a political allegiance to that country. Certainly in the hypothetical I just provided, that would not be the case, and it wouldn't be good policy either. So because of the original understanding of what subject to the jurisdiction thereof meant, which is contrary to what the Supreme Court held in the United States versus Wong Kim Ark, and because of the unreasonable policy ramifications of interpreting it in a manner inconsistent with that original meaning, Trump's executive order may, in fact, pass constitutional muster.
Boy, that was wild. Okay, so the thing is, you actually think it would pass constitutional muster. So it looks like we have two people that believe that this Trump thing isn't going to go through, and two people that believe it would not. But let's take a look at this. We got to go all the way back to 1898, where there was the U.S. versus Wong Kim Ark. So what you're saying, Adam, is you believe that the Supreme Court, because this will eventually get to the Supreme Court of the United States, is going to overturn nearly or over 100 years of decisions to allow Trump's executive order to take place. Is that what you're saying?
I'd like to jump in on Kim for a second, because here's the thing. This is why Kim shouldn't be mentioned. In Kim's case, we had two Chinese parents who were here legally for 20 years. They entered into the United States legally, and they were here for 20 years legally. Their child went overseas, I believe, to China, and then tried to return, and they said, no, he is a U.S. citizen because he was born here. But they were here legally. So this is a different issue than Kim, because now we're talking about somebody illegal.
Yeah, I agree with that. And Nick, first of all, the Supreme Court is conservative. Second, they have shown no reticence to overturn well-settled precedent, as you saw in Dobbs versus Jackson's Women's Health. And third, when you go back to subject to the jurisdiction thereof in its original meaning, it did not mean that just because you are physically present and technically under the authority of the country that you are subject to the jurisdiction. It also meant, according to the drafters, that the person consented via a political allegiance to that country to be subject to that jurisdiction. That's why my hypothetical about the woman from Tijuana would not result in that child being a U.S. citizen, and why, as was just stated, U.S. versus Wong Kim Ark is distinguishable and will be overturned.
Nick, by Adam's reasoning, Lee Harvey Oswald wouldn't have been considered a U.S. citizen, and we don't have jurisdiction over him. Now, how could that possibly be? He commits a crime killing the president of the United States, but he didn't have allegiance. Maybe he even defected prior to that. And I know what Adam would say. He would say, well, he's subject to our criminal laws, but he didn't owe allegiance to the, and so he owed allegiance to the United States. He was born here, whatever. But he swore allegiance, I believe, to the Communist Party and lived in Russia or something like that. I think this attempt to divide political and allegiance to the United States from or political jurisdiction from judicial jurisdiction twists the amendment beyond its historical moorings as well as beyond the language. I think jurisdiction is jurisdiction. I think you look at Pennoyer versus Neff, touchstone, the touchstone of jurisdiction is presence. And I do think the example Adam gave of Tijuana, well, that baby might have been born in the United States, but is it subject to the jurisdiction if the mother took it back to Tijuana right after it was born? I think there might be a question about that, but I really don't think that's where most of these cases are coming from. Somebody that, swims the Rio Grande while they're 9 months pregnant and then goes back that night. And, several years later, the baby wants to try to get back in and be a U.S. citizen. I think that's that would be a very exceptional and rare case.
Well, I would say that the distinction is not one that I'm trying to draw. I'm going according to the original meaning of the provision because I'm an originalist, and the originalist did draw that distinction. Furthermore, given our conservative court and given the policy considerations, I think there are strong policy considerations to say that that child born in San Diego should not be a citizen and that we should interpret subject to the jurisdiction thereof as was originally intended.
So, yeah, I'm an originalist too, and that is, I'll get into my what I believe is the strongest argument. So there have been Supreme Court cases on lots of things that have been overturned and sometimes held, but the real question is what was right. And so we go back to the original intent of the constitutional amendment when it was passed. Now, on one side, first of all, it was right after slavery, and there were two other amendments within those years giving slaves the rights under the Bill of Rights. But here's the main thing. So then this is interesting, I think. So first of all, the first significant law restricting immigration to the United States was the Chinese Exclusion Act of 1882. So in 1865, when they were protecting the slaves, in 1867, in 1868, in 1870, when these three amendments were passed, there were no illegal immigrants because they couldn't be illegal. There was no restriction against illegal immigrants because it wasn't an issue for the United States. In 1917, the U.S. Congress enacted the first widely restrictive immigration law. It was passed because of security concerns. And finally, there was enough political will to say, well, we're concerned we're in a war, so we're going to restrict immigration more. Again, now there are illegal immigrants. So one, how could the original intent have been to allow millions of people to come into the United States illegally and have babies here when it didn't exist? And if you went back, and this is hypothetical, nobody can answer this question, but let's go back and pretend we're going back in time to the 1860s, and we're asking them, would you want this to allow millions of people to have babies here illegally, or thousands of people to come in to the United States by traveling in on birthright citizens tourism? And then would you want this to be the interpretation? I don't think that would be the case. And especially I'd make the final point that our country is in so much debt. On Wall Street Hackers, which was my old show, I used to point this out all the time. We are $125 trillion in debt, according to David Walker, who was the former Comptroller General of the United States. We are possibly bankrupt. I mean, literally bankrupt. 125 trillion, counting our obligations for Social Security and Medicare, is more money than the U.S. stock market, the U.S. bond market, all privately held real estate in the United States, and all commercial real estate in the United States. Basically, all the wealth of the United States is a little bit less than 125 trillion. Because can the United States be paying for people to come here and have babies? Because we do, taxpayers pay a lot of it. And also, can we afford millions of births here when a lot of these people who are illegally here just don't have $30,000 to have a baby? So the taxpayers are eating it. So we have to act as if and this is true beyond this, we have to act as if this country might be bankrupt because we are in big trouble financially. So the practical thing, and going back to 1860s, argues for the intent being to help the slaves. And that's my strongest argument.
But what you're saying, Counselor, it has nothing to do with the law. You're arguing political
the second part
position.
doesn't. It's the reality. No, the
So
first
it doesn't matter. It doesn't matter what the reality is. What
No,
matters is what the law says.
No. The first part is the intent, though. I'm arguing the original intent legally. In other words,
The law is pretty clear.
there were no illegal immigrants.
Nick,
There were no illegal
You come
aliens
to
in
the
the
United,
world.
if you're born in the United States, you're a citizen of the United States,
Well, that's
and
the
you're
argument.
subject to the jurisdiction of the United States. Can you imagine somebody comes to the United States, they're born here, which
Right.
is the intent of the law, they're a citizen here, and they said, "But wait a minute, I came in from Venezuela. They're not making me a citizen there because I was never born there. I was born here, and when they're born here, they're subject to the jurisdiction of the United States." It doesn't matter where their parents came from. It's
Yes,
where
it does.
they
Because if
came
their
from.
parents were Venezuelan, they would be
So
Venezuelan.
it's pretty clear that the Supreme Court's going to look through all the political garbage that you're spouting out here, and they will declare this person, that the executive order of Trump, to be just another executive order that is totally illegal, and toss it.
That's what we're debating now. But the other side is that Venezuelan parents, if they're here legally or illegally, would have Venezuelan citizenship because they're from Venezuela. And, the question is, do they get U.S. citizenship? Again, going back to the 1860s, that's my legal argument. The other part is the reality. The reality is we have got to start waking up in this country and doing the right things financially, because we're maybe bankrupt. But whether or not we're bankrupt isn't the legal argument. The legal argument is in 1867 and 1868, there were 3 amendments all about slavery. And the legal argument is, when there was no illegal alien immigrants in the United States, because they didn't exist. So could the intent have been to let millions of illegal immigrants come into the United States and have children here? Or would the intent have been to help the slaves? I argue it would be to help the slaves.
Nick, if I could back you up real quick. For one thing, I agree with your argument that the policy arguments don't change what the Constitution says. I'm not in love with birthright citizenship either, but the problem with the policy arguments is the plain language of the Constitution. Now, I know we're hearing that, well, if we asked the people back then, this is kind of the original public meaning argument. If we asked the people back then, does this mean we want millions of people coming over here and having babies and they would then be U.S. citizens? Look, I don't necessarily buy that this was not an issue at the time. The amendment says all persons born or naturalized in the United States. It foresees some kind of immigration policy that people can become U.S. citizens even if they're not born here, if they follow the naturalization process. Secondly, I also don't, I don't buy this idea that birthright citizenship requires us to admit millions and millions of people into the country to have babies and then stay here. The problem I have with the anchor baby situation, even with the plain language of the 14th Amendment, is a baby born here and subject to the jurisdiction, in other words, if they're not born to a diplomat or their spouse, a baby that's born here may be a citizen and may be entitled to stay. Doesn't mean we have to allow their parents to stay here. The parents, if they choose, can leave the kid with a friend or a relative that's legally in the country, but they can be deported and sent home if they're here illegally. And if they want to take their baby with them, I think they have the right to do that. So I don't think we have to allow an anchor baby to be an excuse to leave a whole bunch of illegal immigrants here in the country, or let somebody come in on a tourist visa and stay forever because they have a baby here. So in terms of the policy argument, it doesn't really work for me. But I also am not going to just whitewash it and say, well, the Constitution means what we say it means because we're on the verge of bankruptcy. Well, we are on the verge of bankruptcy. I'm surprised our economy is as good as it is, given how much debt there is. But to me, that's a separate issue. Someone born in the United States that is subject to the jurisdiction of our laws, whether that's an invading army or someone who snuck across the border or whatever, a person that sneaks across the border has no allegiance to the United States, right? But that doesn't mean they can't be arrested and made subject to our laws. And I think the idea is ridiculous that we could arrest an illegal immigrant and he could say, you can't arrest me, you don't have any jurisdiction over me. No, I don't buy it. I don't buy it for the world
Nick,
in which this amendment was written.
Nick, here's what I would say to that. So the drafters of the 14th Amendment had a choice. They could have written, all individuals born or naturalized in the United States are citizens. They didn't write that. Instead, they wrote, all individuals born or naturalized in the United States and subject to the jurisdiction thereof are citizens. So that has to mean something. They could have drafted it differently to ensure that anybody born here was a citizen, but they didn't. So what does subject to the jurisdiction thereof mean?
Means they're not a diplomat with diplomatic immunity.
Well, I think what it means is that not every single person who was born here is going to automatically get citizenship. There was something more. So what does that phrase, subject to the jurisdiction thereof, mean? Well, the historical record suggested it meant that they had political allegiance to the United States. Jeff's right. It may not be a good idea, but I'm an originalist, and I'm going to give effect to that. And if you want to change that, let's do it through the amendment process of the legislature.
What do you mean amendment process of the legislature? You're talking about a constitutional amendment. You know, the thing is, what we need to do, if they want to change this, if they want to get rid of birthright citizenship, well, then I would agree with you, Adam. They need to do a constitutional amendment. But you
tell me what subject to the jurisdiction means. They could have made it clear.
But what are you trying to say? You're trying to say that certain people that come across the border are not citizens, and certain people that came a different direction are. So you're trying to make this totally different. And
Yes,
if you want to get rid of birthright citizenship, then go put a constitutional amendment together that says birthrights.
I don't need it. I have the text.
Why didn't they do that? Why didn't they just say, hey, if you're born here, that doesn't necessarily mean you're citizenship.
Well,
citizen.
let me
Why
say
did they
that,
just do that, Jeff?
let me say that
The
there
jurisdiction
is an interpretation.
otherwise.
There is an interpretation that's backed up with some of the original intent. If you look at the writings at the time, that there was two definitions of jurisdiction. Now we think of jurisdiction as we were discussing it earlier, that you're right. If an illegal alien is here, he's still subject to the legal jurisdiction. He could be prosecuted. But there was another meaning back then, and there is evidence that is what they meant too. One of the drafters of the amendment, actually, if you look back at the writing, that it was a political jurisdiction they meant too, meaning loyalty to the United States. And that is the argument that it will all come down to. What is the meaning of jurisdiction? But there is an argument to that effect. And I would hope that the Supreme Court would interpret it in the way best for the country and say, you know what, there's two meanings to that. And also our intent, again, back then was more about slavery, and they meant loyalty to the United States and not loyalty to another country. So, but that's what it will come down to.
Yeah, but the thing is that this is not a proper forum to do this. I mean, if you're looking at what really happened,
Well, that's what
the dictator in chief, Donald Trump, puts a executive order saying, well, basically, birthright citizenships in the United States no longer exist. He can't do that because the thing is, it's very clear that birthright citizenship does exist. So the thing is, his executive order is wrong. It'll get struck down faster than the lightning bolts that hit the Tampa Bay area.
If courts,
The thing is, it's totally wrong. You just don't hand somebody the dictatorship in chief and let him strike Constitution like it's no tomorrow. So there's a proper form for him to do it, and that's to put a constitutional amendment together and saying that birthright citizenship no longer exists in the United States.
Well, we're running out of time, Nick, but I would
He
add,
doesn't have the power to do that.
your interpretation would render subject to the jurisdiction thereof totally superfluous.
Right. So, but you know what? That's the issue that the Supreme Court will be facing very soon.
Oh, then you're going to have to take
right,
it on a
if they
case by case
rule-
basis.
If they
Who
rule
is
against
subject to the jurisdiction? If
So let
somebody
me-
comes, let's get back to your pushing across the Rio Grande.
Nick, I hate to mention this, but we're running out of time right now, aren't we?
Yeah, we are. All right.
Yeah.
Well,
I'll conclude with the fact that that is the issue. It's going to be the interpretations that we've been discussing today. And you're right, Nick, if they rule against it, then the practical thing is it will remain. It's not good for the country financially, but it will remain. But a constitutional amendment getting 66% or whatever it is of the states to ratify a constitutional amendment will be quite a project. And so it'll remain a long time if the Supreme Court rules that way, and we will see.
and we definitely will see, and we'll see you back next time on The Lawyer's Den. Bye-bye.
I can feel my body hold against the concrete, but I can't seem to get enough. My mind is fixed on what it wants. I just let you beat me. Looks can be deceiving. Let you get the best of me. In bed with my worst enemy. This is a no-go. I just can't take hold. This is a danger zone. Back up and get me home. This is a no-go. I just can't take hold. This is a danger zone. Back up and get me. So put your hand in mine. Follow me. Let me waste your time. Set up feet. Do some stupid shit. Take a seat. Let me waste your time. Scroll beats up a tower.